Good afternoon, everyone. Welcome to Truly Sinister. Today, we're going to go over a bunch of stuff. Last Friday, in the Karen Reed's um, civil case, the O'Keefe's wrongful death case against Karen Reed, there were multiple things entered on the docket. I mean, if you have a full-time job, it's hard to keep up with this case. They're constantly filing new motions and new this, new that. So we're going to go over all that, or most of it, what we can today, and that's it. See if we can get it through it all. So stick with me, and I'll be right back. So thanks for hanging out with me today. I hope everybody had a good weekend. I worked, so that's why we're running behind. I know Melanie Little has gone over all of these, and even she's having a hard time keeping up, and she does this pretty much full time. So, yeah, it's quite the conundrum. Um, so, first, we're going to go over Karen Reed's emergency motion for reconsideration of order delaying deposition of Michael Proctor. Yeah. He's just trying to get out of giving his deposition. It's insane. I used to like Judge Gildea, but I've got to tell you, I'm slowly starting to not like him so much. He is starting to show some bias, and especially towards Turtle Boy. And my feeling about that is that if he is expected to hear the case against Aidan Kearney and Karen Reed for the defamation civil case against them, I'm not sure he can be impartial. He's not showing any signs that he can be impartial as far as Aidan Kearney goes. And he's also starting to show some signs that he can't really be impartial with Karen Reed. He's making little snide comments here and there that are audible to those of us watching. And his attitude since he started presiding over this case has changed significantly, I think, in my opinion. I don't know if somebody got to him because, they are not elected judges, they are appointed. So if he's worried about keeping his, judgmanship or whatever it's called, if he's worried about staying on as a judge, as a presiding judge from Massachusetts, he could possibly be, I don't want to say coerced, but influenced to maybe lean one way or the other. I hate to think that way, but after Judge Kearney, nothing surprises me anymore when it comes to Massachusetts and their legal system. I think it's everywhere, but this is where it's most prominent at the moment. So that's what I'm focusing on. And that's why I make this narrowed statement towards Massachusetts. So here we go. This was filed on July 8th. It's the emergency motion for reconsider because, the judge denied her motion to have the delay in Proctor's second deposition lifted because, there was no leak. It was all on the up and up, and I don't know if he has a problem admitting he's wrong or what, but he's showing some signs of irritation towards Karen Reed and her team. So, anyway, emergency motion for reconsideration of order delaying deposition of Michael Proctor. Defendant Karen Reed respectfully requests that the court reconsider its June 29th order staying further discovery of Michael Proctor. The court stated on the record that it had stayed the second day of Proctor's deposition because an attorney with an appearance in this case had, quote unquote, violated either the letter or spirit of the rule. That statement is incorrect. First, the ex post that the court cited as the only evidence that its impoundment order had been violated was actually posted before Proctor's relevant June 8th, 2026 filing. Second, the information that the court claimed had been disclosed by an attorney was already public as of June 6, 2026 at the latest. Let me see something here. Sorry, I don't know what I'm doing there. My bad. Okay. Okay, let's read that sentence again. Let's go back and read that little statement again. First, the ex post that the court cited as the only evidence that its impoundment rule had been violated was actually posted before Proctor's relevant June 8th, 2026 filing. Second, the information that the court claimed had been disclosed by an attorney was already public on June 6, 2026 at the latest, more than 2 days before the filing or impoundment order at issue. Footnote 1. Reed's counsel was prepared to present the evidence presented here at the July 1 in-person hearing. However, after delivering its prepared remarks, the court left the bench and refused to allow any party to be heard, which is true. We all heard Alan Jackson asking the court officer if he could go back to the judge's chambers and ask the judge if he could come back out to the bench so that they can respond. And apparently it either didn't happen or he said no, because he didn't come back out. Thus, the foundation upon which the court relied to suspend Proctor's deposition was mistaken, and the court should vacate its order to avoid unnecessary delay in discovery, particularly when the second day of Proctor's deposition is already scheduled for July 14th, which is tomorrow, I believe. Footnote 2. And he's the one that's got his panties in wad, so to speak, about the discovery being done by this deadline that he set. And yet he keeps pushing everything back. Footnote 2. Reed brings this motion to an emergency basis because the second day of Proctor's deposition is already scheduled for July 14th, and all counsel and parties have already planned for that date. To fly in for this. It is particularly, and he didn't rule on it today that I know of. I don't know. She did have a hearing this afternoon, so I'm scratch that because I'm not sure. The second day of Proctor, okay, where is it? It is particularly important to protect the scheduled date because Proctor previously asserted that he had limited availability. It would be unduly and unnecessarily costly and burdensome to force Reed to miss a previously scheduled deposition day because of the order, which was based on an incorrect premise. Were Reed to serve the motion via Rule 9A, the opposition would not be due until after that currently scheduled date. Reed's counsel conferred with Proctor's counsel concerning this motion prior to filing it. And she probably put in that footnote because she knows that the judge is going to, say this is improper and you should have filed it this way and then, so they bypassed that whole response and just put it in the footnote as to why they did it this way. The post in question was created at 10:52 a.m. Eastern Time. The court stated at hearing that it was staying further discovery of Proctor because Proctor's counsel sent certain impounded pleadings and exhibits to the court and counsel at 2:22 p.m. on June 8th, and that the ex post in question was created, quote unquote, exactly 30 minutes after the email to counsel of record, and contained information, quote unquote, similar to the information contained in Proctor's filing. That is incorrect. As the court can see below, the ex post in question, which was provided to the court by Proctor's counsel in a letter that prompted the court's June 30th order, was created at 10:52 a.m. Eastern Time. And it was provided by Proctor's counsel in an ex parte communication, if you ask me. Right? Wasn't it? He sent it to the court, to the judge. The image provided by Proctor's counsel had a 2:52 p.m. timestamp. However, that is because it was apparently accessed by a user with no X count, which defaults the time zone to Coordinated Universal Time, UTC, 4 hours ahead of Eastern Time. 4 hours ahead of Eastern Time, period. When accessed by a user with an account set to Eastern Time, the post appears as follows. Aidan Kearney. And the fact that the judge was so quick to believe that Aidan Kearney leaked this shows his bias against Aidan Kearney right there. Instead of looking into it further, he just chose to believe it and made an order to the court accordingly. So, he's already got a tendency to believe anything bad about Turtle Boy, which how do you judge a case concerning Turtle Boy or Aidan Kearney if you feel that way already? You can't be fair. Michael Proctor decided to have this is what Aidan Kearney's post said on X. Michael Proctor decided to have a mental health crisis after the whole world found out how racist he is. Sources tell us he checked himself into a mental health facility in Florida to try to avoid today's deposition. They filed a motion at the last minute on Friday to delay the depo, but the judge wanted proof. They submitted an affidavit that was impounded because it likely said Proctor was in a mental hospital. Karen Reed's lawyer made the mistake of saying the scheduling of the deposition was strategic, which the judge took issue with based on her comments on the Today's Show. He stayed the depo for 24 hours, and at 4:15, a hearing will be held. My guess is he's going to tell Proctor to jump on a plane and stop being such a P word so Alan can depose him tomorrow. 10:52 a.m. 167,000 views. So it's out there already. The message was actually posted more than 3 hours before Proctor's filing and not, quote unquote, exactly 30 minutes after. Therefore, it does not prove or suggest that anyone has violated the court's impoundment order. The information in the X post the court's referred to was public 2 days before Proctor's counsel served the pleading and exhibits the court needed, or the court relied on to justify its order. On June 6th, the ex-user the court referred to on July 1 held a live stream on YouTube during which he stated that he had received the same information from a third party. That was 2 days before the impounded filing the court believes was improperly shared. That YouTube clip is contained on the USB drive attached as Exhibit 1. Let me see if I can find that YouTube comment, that YouTube live from Turtle Boy. Okay, so I found it. Let's... Okay. Ready?
Okay, I found it. Never mind. I got it. I got it. All right, let's pull this up. All right. So let's just go down the list. I got it. Is this her sending it to me? Let's see. Got a text from Emily C. Let's see what it says. No, she sent it to me. Okay, cool. Yeah, we got that one. All right. So, oh my goodness gracious. It's so horrible.
Sorry, that wasn't it. That was the second group of Michael Proctor's texts. So let's see if we can find the email. Sorry. Okay. I believe I found it this time. Sorry.
Was this the interview? Elizabeth Proctor and Courtney Proctor speak up again. This is in March of 2025 in defense of Michael Proctor, and they claim Karen Reed is guilty. How it is crossed from vile messages on the internet into our physical lives. We have seen the worst of our society through social media.
Sorry, that's not it again. Okay. I was going to look for that recording. I can't find it. So here we go. There we go. It is what it is. Okay. The following posts that also predate the June 8th impounded filing also show that the information in question was public prior to that filing. These are the different posts. Footnote 3. Reed is mindful of the court's prior statement to counsel that social media posts, quote, are not evidence, end quote. However, they are relevant here because the court expressly relied on social media posts as justification for its order, which, yeah, he says that social media posts aren't evidence, yet he's taking the word of a social media post, which you could say is evidence then, right? I don't know. The court's remedy for what it incorrectly determined was a violation of its impoundment order has primarily impacted Reed, who is the party who subpoenaed Proctor, began taking his deposition, scheduled a second day of testimony, and has spent significant resources compelling and taking his testimony. Additionally, despite the fact that there is no evidence of any violation of the court's impoundment order, Reed has, as the court instructed, made a proposal to all parties concerning an order she would agree to propose to the court concerning deponent's medical information. No other party has responded to Reed's proposal. There you go. He's always wanting them to solve things on their own, but nobody ever responds to her or her lawyers. This comes on the heels of Reed earlier proposing to all counsel that witnesses' testimony in transcript, audio, or video form only be used for the ongoing litigation and not otherwise disseminated. As Reed indicated previously, the plaintiffs have never responded to that proposal or multiple follow-ups. Under these circumstances, and to prevent further prejudice to Reed, the court should reconsider its order, vacate it, and permit Reed to proceed with Proctor's deposition on July 14th. Wherefore, defendant Karen Reed respectfully requests that the court reconsider its June 30th, 2026 order and vacate its stay of discovery from Michael Proctor. Respectfully, Karen Reed. Just one second. Okay. So moving right along. Logged me out, so just one second. Let me get to this. Let me see. Okay, so that was so this is going to be Michael Proctor's opposition to her emergency motion to go on with his deposition. This was filed on the 9th, which I believe is Thursday. Okay. Non-party Michael Proctor's opposition to Karen Reed's emergency motion for reconsideration of order delaying deposition of Michael Proctor. Non-party Michael Proctor hereby submits this opposition to Karen Reed's emergency motion for reconsideration of order delaying deposition of Michael Proctor. Cognizant of this court's admonishment to all counsel on July 1, 2026, and Rule 3.6 of the Massachusetts Rule of Professional Conduct, Mr. Proctor will be brief. As if to insinuate that Karen's was not brief, and it's the same number of pages. So anyway, I digress. As an initial matter, Ms. Reed's motion should be denied because it fails to even address the fact that information regarding Mr. Proctor's medical condition and his deposition was disseminated by Aidan Kearney, also known as Turtle Boy, within 30 minutes of the conclusion of Mr. Proctor's June 25th, 2026 deposition. Specifically, on June 25th, 2026 at 5:30 p.m., Mr. Kearney posted on his X account at Dr. Turtle Boy as follows, quote, "Breaking news, Michael Proctor claimed to have a panic attack today and left his deposition. I have personally verified that he was seen outside being consoled by his lawyers who were asking him if he could continue. No word yet if he did," end quote. This information was accessed by a user with an X account. A screenshot of the X post follows. Footnote 1. Mr. Proctor acknowledges that the X post referenced in Mr. Kearney's June 8th, 2026 post was accessed by a user with an X account. So they're trying to say that the time wasn't wrong on that. Okay. In point of fact, Mr. Proctor did continue his deposition, and the deposition was suspended shortly after 5 p.m. Assuming, arguendo, that the X account did not, quote-unquote, default to 1:30 p.m. Eastern Standard Time, and given that this X post was accessed by a user with an X account, Mr. Kearney posted on X within 30 minutes of the conclusion of Mr. Proctor's deposition that Mr. Proctor, quote, claimed to have a panic attack, end quote, and left his deposition. Accordingly, the fact that Turtle Boy posted that Mr. Proctor left the deposition but had no word that he did continue the deposition strongly implies that Turtle Boy had his information while the deposition was ongoing. More importantly, the fact that Turtle Boy posted that Mr. Proctor claimed to have a panic attack today and left his deposition implies that Turtle Boy was aware of what was said during the confines of the deposition. Footnote 2. As noted above, in response to another X user's request that Mr. Kearney post the pic, Mr. Kearney responded, "Can't, unfortunately." Apparently, there was a picture taken of Michael Proctor outside of the courthouse having his panic attack and crying and being consoled by his lawyers. I believe that's the picture they're talking about. To be clear, at no point has Mr. Proctor pointed the finger or otherwise accused any counsel or party of disseminating impounded information. Well, then how would he have gotten it if they didn't give it to him? Mr. Proctor takes no position on that point. Given, however, the existence of the court's orders of impoundment and the sensitive nature of the impounded information, Mr. Proctor felt it appropriate to bring to the court's attention information which created a reasonable inference of a violation of the court's orders. As the court noted during the July 1, 2026 hearing, all parties and counsel certified to their lack of knowledge as to any facts regarding the potential dissemination of the impounded information. But now they've pretty much confirmed that Turtle Boy was right by this because they're saying it was leaked, which means the information is correct, right? Otherwise, they wouldn't think it was leaked if it wasn't even the right information. Mr. Proctor's June 25th, 2026 deposition went forward for approximately 4 hours and 30 minutes with several agreed upon breaks. Mr. Proctor is a fact witness in this litigation and not a party. Despite having the opportunity to depose Mr. Proctor for hours, at no point did Ms. Reed's attorneys ask a single question regarding Mr. Proctor's investigation into John O'Keefe's death. Not a single question about Mr. Proctor's investigation into Ms. Reed's involvement in his death. Instead, Ms. Reed's counsel spent much of the deposition questioning Mr. Proctor about various text messages that Reed's attorneys published currently pending against the Canton Police Department and the MSP. None of these questions were relevant nor material to Mr. Proctor's investigation, nor were they relevant to the subject matter of this wrongful death action. It goes to how much effort he put into the investigation, so I would say it's definitely material that should be allowed in. Such questioning can only be viewed as harassing in nature. Accordingly, should the court allow Mr. Proctor's deposition to continue, Mr. Proctor requests that the court limit it to 3.5 hours of deposition testimony. So now you're going to put a time limit on it. Talk about a violation of your rights. I mean, finally, Mr. Proctor points out that on June 18, 2026, counsel for Mr. Proctor requested from Ms. Reed's counsel assurances that neither you nor anyone on Reed's team will disseminate to any outside source, including but not limited to media and or social media platforms, any portion of the deposition, whether in video, audio, or transcript form. Despite being the party that subpoenaed Mr. Proctor and the only party that questioned him on June 25th, Ms. Reed's counsel has continued to state that they will not provide such assurances. Regardless of whether the court allows Mr. Proctor's deposition to continue, Mr. Proctor respectfully requests that the court issue an order to Ms. Reed's counsel prohibiting them and anyone on Ms. Reed's team from disseminating to any outside source, including but not limited to media nor social media platforms, any portions of Mr. Proctor's deposition, whether in video, audio, or transcript form. Respectfully submitted, interested party, Michael Proctor. So, okay, so it's going to make me, okay. Next is now this is Karen Reed's reply to their opposition. Okay, and this was filed on the 9th also. Reply in support of emergency motion for reconsideration of order delaying deposition of Michael Proctor. In her motion, Reed addressed the information the court referred to as the basis for the order. Reed asked the court to reconsider. The court entered that order because it concluded that impounded information had been shared with a non-party. As explained in Reed's motion, there is no evidence that that occurred. Thus, the order based on that conclusion should be vacated. As the court and Michael Proctor's counsel are aware, Reed has already specifically addressed the different ex post included in Proctor's opposition. Reed did so in Reed's letter to the court in response to Proctor first raising this issue in a letter on June 26th. As Reed explained in that letter, the post Proctor cites from Aidan Kearney itself states, Proctor was seen outside being consoled by his lawyers who were asking if he could continue. No word yet if he did. Someone outside of the deposition saw him and Mr. Kearney was unable to report whether or not the deposition concluded. This does not suggest in any way that someone in the deposition shared any information with anyone. In fact, it suggests just the opposite. Proctor spent multiple hours outside the office where the deposition took place and presumably some time outside the office building. Kearney shared made its way to him because Proctor and his counsel were observed in public. Other social media activity provides even more detail about how this information became public. This post is from somebody named Dex. He showed up and had a panic attack in the hall outside. Prediction or fact? I saw it with my own eyes on a security camera, but cannot share it. So the fact that they saw it with their own eyes on a security camera, does that mean it's a court officer or somebody? Because if that's the case, that's an issue, and it needs to be addressed immediately, because that's not okay. All of the available evidence suggests that the information in question came from someone unrelated to this case. The remainder of Proctor's opposition is essentially a motion for a protective order, which Proctor has not filed and Reed has not had an opportunity to oppose. If Proctor serves or files such a motion, Reed will oppose it. The opposition will point out that 1, Proctor's description of Reed's counsel's questioning is inaccurate, and 2, Reed's counsel extended Proctor the courtesy of delaying the start of the deposition for 2.5 hours to accommodate Proctor's stated needs and should not now be punished for that as Proctor requests. Finally, Proctor's statement that Reed's counsel, quote unquote, has continued to state that they will not provide assurances regarding the use of deposition transcripts and recordings is false. Reed's counsel has repeatedly and consistently, including a Rule 9C conversation yesterday with Proctor's counsel, stated that Reed will agree to the restrictions Proctor's counsel requested if all parties to the case agreed to them. Emails evidencing Reed's attempts to obtain all parties' agreement have been previously filed with the court. Period. Plaintiffs have refused to respond to Reed's proposal, which mirrors Proctor's. So it's the O'Keefes that aren't responding. So they must not want it. Reed respectfully requests that the court reconsider its order staying discovery from Proctor. And then it's signed by Reed. Okay, moving right along. Let's see. Motion for reconsideration of order delayed. Okay, this is the judge's response to Karen Reed's emergency motion. He responded that day. I mean, there's so much happening in one day on this case. It's insane. Okay. Okay, emergency motion for reconsideration of order delaying deposition of Michael Proctor. Defendant Karen Reed respectfully requests that the court reconsider its June 29th order staying further discovery of Michael Proctor. The court stated it on record that it had stayed the second day of Proctor's deposition because an attorney with an appearance in this case had have violated either the letter or spirit of the rule. That statement is incorrect. First, the ex post that the court cited is only okay. me see. Okay, July 10th, 2026. I have been presented with a motion for reconsideration of my order precluding further attempts to take discovery from a non-party pending further orders of the court, an opposition, and a reply. Ms. Reed's attorneys are reminded of the provisions of the Superior Court Rule 9A-3 that a reply memorandum is to be, quote, limited to matters raised in the opposition which were not and could not have been anticipated and addressed in the moving party's initial memorandum. The motion mistakes what I said. God. What I said was, quote, orders of the court have been violated either directly or at the very least in spirit, end quote. I did not say what is stated in the motion. Quote, that an attorney with an appearance in this case had violated the letter or spirit of the rule, end quote. I also did not state on the record that I had stayed the second day of Proctor's deposition, but rather stated that because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. Same thing, right? I acknowledge the information in the motion as to the time of a June 8th, 2026 post on X. However, such information does not allay the concerns that gave rise to the order, especially given the content of a June 25th, 2026 post on X. The motion for reconsideration is denied. He's the one that said it was directly related to a post on X. So now he's changing what he said. Apparently, hypothetically, allegedly, whatever. It's like, what the fuck? I don't get it. Okay. Review discovery. Okay. Okay, this is filed on, it doesn't say, does it? In an order relative to docketing. The notice pleading e-filed on July 9th, 2026 at 3:46 p.m. by Ms. Reed's attorneys shall not be docketed. I appreciate counsel seeking to keep me informed, but a notice regarding parties conference is not appropriate pleading to be filed, is not an appropriate pleading to be filed. The Superior Court rules include limited opportunity for the filing of notice type pleadings relative to motions seeking reconsideration of decisions made pursuant to, and it cites the statute. Moving parties shall also simultaneously file and serve a notice of motion for reconsideration in the same manner as provided in the final sentence of Rule 9E and Rule 9E relative to motions to dismiss. A party must file with the court a simple notice of motion to dismiss. So they're saying she filed her motion incorrectly, so they didn't docket it. The parties should refrain from filing such notice type pleadings unless they are required under applicable rules or are requested by me. On July 1, 2026, I did encourage her attorneys or the attorneys to confer and to seek to reach an agreement. And I further stated that in the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. In my July 6, 2026 order, I stated if no such agreement was filed before 4:30 p.m. on July 9th, I would issue further orders I deemed appropriate. I did not request to be notified as to the progress of discussions between counsel. I was seeking to put the emails relative to communications from various counsel on such issue on the docket. the deck. So he's, like I said, he's making little digs at Karen Reed constantly, it seems like, anymore, and I don't know what is going on as far as that goes. It's crazy. Okay. That's all I have for the wrongful death case. Let me see if I can find anything in the defamation. I know that there was a motion filed by not Mark Betterow, but by Turtle Boy's attorneys. Let me see if it's on here. Hearing. Okay, defendant Karen Reed's certificate of compliance. Opposition to defendant Karen Reed's motion to reschedule hearing on anti-SLAPP. Let's see what this is. Okay. So that what I just went over is from the wrongful death of John O'Keefe case against Karen Reed by John O'Keefe's parents. These next papers I'm going to read are from the defamation civil case between the should have been suspects and Karen Reed and Aidan Kearney. So this was filed on 7/6/2026. Aidan Kearney's opposition to plaintiff's emergency motion regarding anti-SLAPP hearing and briefing schedule and response to Karen Reed's motion to reschedule hearing. Defendant Aidan Kearney submits. Am I sharing? Okay, sorry. Defendant Aidan Kearney submits this opposition to plaintiff's emergency motion that they be permitted to delay the service of their oppositions to defendant's anti-SLAPP motions, and by extension, the stay of discovery occasioned by the filing of such motions, in the event the court reschedules the July 14th hearing. He takes no position regarding defendant Karen Reed's request to reschedule the July 14th, 2026 hearing on the defendant's special motions to dismiss to a date in August 2026. Footnote 1. Well, yeah, because isn't she supposed to be, they're supposed to be getting Proctor's second deposition on that date. So why would they want to go to a hearing also? They wouldn't be able to. Footnote 1. To the extent the court wishes to continue the hearing to a date in July as plaintiff's request, Kearney's counsel is unavailable for such a hearing on July 20th through the 21st, 23rd through the 24th, and the 28th. The transparent object of plaintiff's motion is to artificially delay the beginning of the statutory stay of discovery under the anti-SLAPP law, so that they can take general discovery in this lawsuit. Such a result would violate defendants' rights under the statute, period. As explained below, plaintiff's request cannot be reconciled with the plain text of the anti-SLAPP statute, the legislative intent behind it, or the Supreme Judicial Court's case law, which all make clear that general discovery must be stayed where, as here, a defendant advances a special motion to dismiss. For those reasons, and the reasons set forth below, if the court reschedules the July 14th, 2026 hearing, Kearney respectfully requests that the court maintain the July 7th, 2026 deadline for plaintiffs to serve oppositions to the anti-SLAPP motions and for defendants to file the motions and oppositions, at which time all discovery will be stayed at the statute as the statute requires. And they missed that because this was filed on July 9th. So they missed the deadline if they so choose to reschedule the July 14th hearing. If the court chooses to do that, then the plaintiffs have already missed the deadline. Argument. The third paragraph of section 59H provides all discovery proceedings shall be stayed upon the filing of the special motion under this section, provided, however, that the court on motion and after a hearing and for good cause shown may order that specified discovery be conducted. The stay of discovery shall remain in effect until notice of entry of the order ruling on the special motion. As the SJC has repeatedly explained, the legislative intent behind the automatic stay is to protect special movements from the burden and expense of discovery before a court has considered and ruled upon a special motion to dismiss. Then it states a case, and this case is explaining that the special motion to dismiss is a procedural vehicle intended to secure the early dismissal of a meritless SLAP claim along with attorney's fees before significant discovery has occurred. So they want you to go through all this discovery and everything only to have the case dismissed. So they want to do it, be heard on the motion to dismiss before they waste all this time and money on discovery. Upon the timely filing of a special motion, discovery is stayed to prioritize the resolution of the motion over other matters in the case. If granted, plaintiffs requested relief, an artificial extension of the filing date for the sole purpose of taking merits discovery would undermine the purpose of the automatic stay and require defendants to incur the significant expense of discovery. On June 25th, 2026, despite the impending anti-SLAP motions, plaintiffs served document requests on both Kearney and Reed. In their emergency motion and their opposition to Reed's motion to reschedule the hearing, plaintiffs revealed that if their requested relief is granted, they intend to take 4 third-party depositions and quote-unquote serve additional written discovery. Opposition at 2 and 3, requesting time to take the depositions of 4 Karen Reed family members and to serve additional written discovery. If Kearney is forced to respond to such discovery and participate in such depositions before his special motion is resolved, his immunity from suit afforded by Section 59H will be compromised. Then it cites a case abrogated on other grounds by Bristol Asphalt, similar to the protections afforded public officials by the doctrine of governmental immunity. The anti-SLAP statute is intended to immunize parties from claims based on their petitioning activities. Citations omitted. Holding that the denial of a special motion is immediately appealable because the statute's protections are in large measure lost if the petitioner is forced to litigate a case to its conclusion before obtaining a definitive judgment through the appellate process. Plaintiff's requested discovery period is inconsistent with the plain text of Section 59H, which allows for specified discovery on motion and hearing only if there is a good cause to believe that specified discovery will resolve a disputed issue relating to the special motion itself, not to the merits of the parties' claims and defenses. So only if their motion for discovery has anything to do with his motion to dismiss should that discovery be allowed. Otherwise, it's not. It should be on automatic stay until his motion is decided all the way up through the appeals process. So their motion for discovery should be thrown out. Affirming denial of depositions where cause did not present the exceptional circumstances in which discovery may be required to learn the facts that indicate that a special motion to dismiss is warranted or to test the veracity of factual allegations bearing on the special motion, plaintiffs do not contend, nor is there a basis to contend, that the written discovery or third-party depositions they wish to take have any relevancy to special motions to dismiss. Under these circumstances, if the court were to grant the plaintiff's requested relief, it would create a discovery window expressly foreclosed by the legislature. Ultimately, the protections afforded by the anti-SLAPP statute against the harassment and burdens of litigation will be lost if plaintiffs are permitted to take discovery at this stage. Finally, maintaining the current filing schedule will afford the court a reasonable period to review the extensive briefing and factual submissions associated with the motions before any hearing. Plaintiff's proposal to delay the filing of the motions until shortly before the hearing would be of no assistance to the court. Conclusion. For the foregoing reasons, Defendant Aidan Kearney respectfully requests that, in the event the court reschedules the July 14th hearing, it maintain the July 7th filing deadline and confirm that all discovery is stayed upon the filing of the defendant's special motions to dismiss as required by Section 59H. Respectfully yours, Aidan Kearney. That was filed. When was this filed? 7/6. I think I already said that. So now then we have Karen Reed's motion to reschedule a hearing. Okay, motion to reschedule a hearing on anti-SLAPP motions in response to federal court hearing in an earlier filed case and incorporated memorandum. Defendant Karen Reed respectfully requests that the court reschedule the hearing on defendant's special motions to dismiss pursuant to the anti-SLAPP statutes until August 3rd, 2026 or thereafter. That hearing is currently scheduled for July 14th at 2 p.m. However, Judge Denise Casper of the U.S. District Court for the District of Massachusetts has also scheduled a hearing that same day at 3 p.m. on plaintiffs Jennifer McCabe, Brian Albert, and Brian Higgins' anti-SLAPP motion in the case pending before her between the same parties. That federal case, which was removed to the District of Massachusetts by the above-named plaintiffs, among others, predates this case by 7 months. Therefore, Reed requests that this court reschedule its July 14th hearing to permit the significantly older federal case to proceed. Reed requests that the court reschedule the hearing during the first week of August, 3 weeks after the current date, rather than the end of July because there are depositions scheduled or to be scheduled pending the court's rulings on motions to compel on most days through July in the O'Keefe VCNC Hospitality et al. Case pending before this court, including depositions of at least 3 of the plaintiffs, as well as some of their family members who are represented by the same counsel. Therefore, the 3-week continuance Reed seeks in the newly filed case is warranted and will not unjustly prejudice any party. On June 25th, 2026, plaintiffs' counsel raised this scheduling issue with defendants' counsel and indicated he was inclined to ask for the July 14th hearing to be rescheduled. However, once Reed agreed generally to the need and proposed seeking an August date, plaintiffs reversed course. Of course they did, and did not agree to jointly seek a continuance unless Reed agreed that the anti-SLAPP statute's stay of discovery would not begin until shortly before the rescheduled hearing. Footnote 1. This argument is directly contrary to the purpose of the anti-SLAPP statute's discovery stay, which is to protect a defendant from incurring the cost of discovery prior to the court deciding a special motion to dismiss. Wherefore, defendant Karen Reed respectfully requests that the court allow this motion and reschedule the July 14th hearing in this case to a date on or after August 3rd. Respectfully submitted, Karen Reed by her attorneys. I'm telling you, it's becoming a shit show. So then we have defendant Karen Reed's notice of filing a list of documents. Okay, this is the response to Karen Reed's motion to reschedule. And it says, I thought it just said, okay, that didn't really work out for me. Okay, well, let me read to you what it says on here. It says, it says, anyway, it was grant. It says order, where is it? Endorsement on motion to reschedule hearing on anti-SLAPP motions allowed. The motion is allowed to the extent that the hearing shall take place on July 14th at 10 a.m. I don't get that because that's what they're trying to get it post or rescheduled, right? Let me see. Wow. So anyway, it says that that was allowed. Then the endorsement on the motion regarding the anti-SLAPP hearing and briefing scheduled, no action was taken. It was deemed moot because of the endorsement that he gave for Karen Reed's rescheduling. And then we have Karen Reed's motion for leave to file for her motion to dismiss. That's not. Okay, here's her motion to dismiss. Pursuant to the anti-SLAPP. Must be long. Now remember, this is the defamation case. This is no longer the wrongful death case. I probably should have done 2 separate videos so that people would keep them separate, because it's hard to keep them separate. It's hard enough to keep them separate, and then to do them both in the same video is kind of stupid of me. But it's too late now, so we'll just continue on. Is it gonna show? Come on. Must be long. Okay, let's try that again. Right here. It's not. I don't know why it's not showing. Hold, please. What the fuck? Must be pretty long. Let's hope it goes all the way through this time. Last time it stopped partway. Okay, yay. And this is, there's no way it's 961 pages. I'm sure they double copied everything again like they always do, hopefully. But if it was, then we could at least do a separate stream for this one to keep the cases separate. But let's just see. I think it's 30 pages, she said. So it's only $30 pages, like I said. Okay. So we will try to make it quick. Is it sharing? Yes. This was filed on 7/7. Defendant Karen Reed's special motion to dismiss pursuant to the anti-SLAPP law and motion to dismiss pursuant to Mass R Civil Penal Code 12B6. Introduction. Karen Reed was charged and then prosecuted twice for the death of Boston police officer John O'Keefe III. The first criminal trial ended in a mistrial on July 1, 2024. The second trial, which commenced on April 2025, resulted in an acquittal. Her defense at trial was consistent clear and supported by overwhelming circumstantial, medical, and scientific evidence. She did not kill Mr. O'Keefe and was framed by the conflicted and corrupt police investigators and the individuals in the house at 34 Fairview who were involved in Mr. O'Keefe's death. Plaintiffs have now sued Ms. Reed for speech pertaining to her defense. The legislature, however, has enacted, quote, very broad protection for petitioning activities, end quote, like Ms. Reed's. The anti-SLAPP statute provides civil immunity for the exercise of the right to petition the government. Its protection extends not only to statements made directly to government bodies, but those made in connection with ongoing judicial proceedings and statements reasonably likely to enlist public participation. The statute immunizes the broad category of conduct from suit, except where it is devoid of any reasonable factual support or any arguable basis in law. Here, and as explained below, the anti-SLAPP statute requires dismissal of all plaintiffs' claims against Ms. Reed because they are based solely on her petitioning activity, and plaintiffs cannot prove by a preponderance of the evidence that her petitioning was, quote-unquote, devoid of any reasonable factual support or arguable basis in law. Accordingly, Ms. Reed moves to dismiss the claims against her under the anti-SLAPP statute. And pursuant to Mass R Civil Penal Code 12B6, Ms. Reed also seeks her attorney's fees pursuant to the statute. In support of her motion, Ms. Reed submits the affidavit of Karen Reed and affidavit of Damon M. Sillickson, including exhibits appended thereto. Factual background. Unlike a motion to dismiss for failure to state a claim under Massachusetts Penal Code 12B6, a court, just one second. Okay, let's go back and start that over because I was muted that whole time. Okay. Unlike a motion to dismiss for failure to state a claim under Mass R Civil Penal Code 12B6, a court faced with an anti-SLAPP motion shall consider supporting and opposing affidavits stating the facts upon which the liability or defense is based. Considering exhibits submitted by the parties on anti-SLAPP motion, footnote 1. Each of the exhibits referred to in this motion is attached to the Seligson affidavit. Here, Ms. Reed sets forth the following facts drawn from the allegations in plaintiff's amended complaint and the affidavits and exhibits filed herewith. At count 1 of their complaint, plaintiffs allege that Ms. Reed repeatedly published false statements asserting or reasonably understood as asserting that the plaintiffs were responsible for the murder of Mr. O'Keefe and a cover-up of their purported role in that murder. Complaint 140, paragraph 147. Plaintiffs do not identify the allegedly defamatory statements in count 1, but the complaint only identifies a handful of allegedly false statements by Ms. Reed about plaintiffs. Stating to investigating officers prior to her arraignment that Brian and Colin Albert beat up Mr. O'Keefe. See paragraph 19, which statement was released to the public during a judicial hearing in April 2024. Another one, stating in a discovery motion during her first prosecution that Brian and Colin Albert were responsible for Mr. O'Keefe's death and that Ms. McCabe was the mastermind who covered it up. Forwarding the motion to defendant Aidan Kearney, who then published it. Telling Mr. Kearney through an intermediary, which is Natalie the German, that Brian, Nicole, Chris, and Julie Albert all testified to a grand jury that Colin Albert was present at the Alberts' home at 34 Fairview, telling reporters during her second trial that Ms. McCabe's testimony at the trial was perjured and that she was lying. Well, she was. We have proof of that. Telling a podcast on January 12, 2026, that Mr. O'Keefe entered the Alberts' house and much sooner than later met his demise, and that someone in that house killed John O'Keefe. Well, if he wasn't hit by a car and she didn't hit him by a car, the only other possibility is that he was killed in the house because she's been cleared. So it's on one of you. As described below, all these statements constitute petitioning activity. Similarly, at counts 3, 4, 6, 7, 9, and 10, plaintiffs assert various non-defamation claims against Ms. Reed. Specifically, counts 3, 6, and 9 allege that Ms. Reed is liable for aiding and abetting 3 discrete torts allegedly committed by Mr. Kearney: defamation, intentional infliction of emotional distress, and negligent infliction of emotional distress. They all allege the same activity, that Ms. Reed continuously and intentionally provided defendant Mr. Kearney with non-public and or confidential information about her criminal case. Not. I mean, if you think you're going through emotional distress and whatnot, what do you think she went through for the past 3 years? Counts 5 and 9 allege intentional and negligent infliction of emotional distress based on Ms. Reed's alleged campaign of false and outrageous statements about plaintiffs. 9, paragraph 196, I don't know what 9 means, count based on Reed's campaign of outrageous, cruel, and malicious lies. The emotional distress claims appear to be based on the same statements and conduct underlying the direct defamation count and the aiding and abetting counts. Plaintiff's final claim against Ms. Reed, count 13, alleges a civil conspiracy between Ms. Reed and Mr. Kearney, an agreement to defame the plaintiffs and to inflict severe emotional distress on them. They weren't trying to defame them or inflict emotional distress. They truly believe that somebody in that house is guilty for the murder of John O'Keefe. So if that causes you emotional distress, that's on you because you did the act. For the reasons set forth below, these counts should be dismissed pursuant to the anti-SLAPP statute because they are based on the same statements that underlie count 1, all of which fall under broad definition of petitioning activity in the anti-SLAPP statute. Argument number 1, the Massachusetts anti-SLAPP statute. The Massachusetts anti-SLAPP statute authorizes a defendant to file a special motion to dismiss when facing claims based on the defendant's exercise of right to petition. The statute's powerful procedural protections aim to foster the speedy dismissal of claims based on petitioning unless it was devoid of any reasonable factual support or any arguable basis in law. The SJC has adopted a two-stage inquiry when evaluating a special motion to dismiss. Under the first stage, the movant must make a threshold showing through pleadings and affidavits that the claims against are based on the movant's petitioning activities alone and have no substantial basis other than or in addition to the petitioning activities. If the movant carries its threshold burden, the second stage of the analysis requires dismissal unless the non-movant can prove a negative, that the movant's petitioning activity, one, was devoid of any reasonable factual support or any arguable basis in the law, and two, not or, and two, caused actual injury to the non-movant. The non-movant's second stage burden is a difficult task. The non-movant must establish the lack of any reasonable factual support for the petitioning activity by a preponderance of the evidence. Furthermore, in the case of conflicting affidavit testimony, the reviewing court cannot resolve disputed credibility issues in favor of the non-movant. Thus, the evidentiary support in favor of the special motion proponent's petitioning activity must be quite limited to satisfy the non-movant burden and avoid dismissal. Further, the anti-SLAPP statute provides that if a court grants a special motion to dismiss, it shall award the moving party costs and reasonable attorney's fees, including those incurred for the special motion. Ooh, that'll help. Moreover, the award of attorney's fees is mandatory. Wow. Here, Ms. Reed easily meets her burden of establishing that all of the alleged activity is protected petitioning, and plaintiff cannot meet their burden to establish that her petitioning activity was devoid of any reasonable factual support or any arguable basis in the law. As a result, the court should allow Ms. Reed's motion and award reasonable attorney's fees and costs. Roman numeral 2, the court should dismiss plaintiff's claims against Ms. Reed pursuant to the anti-SLAPP statute. A, first stage, plaintiff's claims are based solely on petitioning activity. At the first stage of the anti-SLAPP analysis, a court need only conduct a facial review of a special motion opponent's pleading to identify which factual allegations serve as the basis for a particular claim. However, the court can consult documents in the anti-SLAPP record to determine whether these factual allegations fall within the statutory definition of petitioning activity. The anti-SLAPP statutes defines petitioning expansively. Statutory definition of petitioning activity is very broad. Indeed, the definition of a party's exercise of its right of petition in the anti-SLAPP statute is very broad and includes several elements that squarely apply to Ms. Reed's speech and actions here, including any written or oral statement made in connection with an issue under consideration or review by a legislative, executive, or judicial body. Any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body. Any statement reasonably likely to enlist public participation in an effort to effect such consideration, and any other statement falling within constitutional protection of the right to petition government. No, okay. Additionally, in order to determine if statements are petitioning, courts consider them in the overall context in which they were made. A facial review of the complaint shows the plaintiff's claims against Ms. Reed are based on her statements, all of which meet the expansive and very broad definition of petitioning activity. 1. Count 1 is based on petitioning activity. At count 1, plaintiffs allege that Ms. Reed repeatedly published false statements asserting or reasonably understood as asserting that the plaintiffs were responsible for the murder of O'Keefe and a cover-up of their purported role in that murder. Plaintiffs do not identify the allegedly defamatory statements in count 1. However, in the complaint as a whole, plaintiffs identify a handful of allegedly false statements by Ms. Reed about plaintiffs. Okay, these are the same statements that we read already. All of these statements by Ms. Reed constitute petitioning activity. First, the statement Ms. Reed made to investigating officers was after she had been arrested and was trying to convince the police officers that the Alberts, rather than her, were responsible for Mr. O'Keefe's death. Therefore, it was an oral statement made before an executive body reporting a violation of law by the Alberts and thus constitutes petitioning activity. Second, the statements made in the discovery motion are similarly written statements made before or submitted to a judicial body. Petitioning activities include statements submitted to a judicial body. Sharing the court-filed document is itself petitioning activity. Concluding that statements made to press that were essentially mirror images of statements made at disciplinary hearing were also petitioning activities. Ms. Reed did not have a commercial motivation. Footnote 3. Notably, the complaint only alleges that Mr. Kearney, not Ms. Reed, acted in the course of trade and commerce and violated the Massachusetts Unfair Trade Practices Act. She didn't make any merch, basically, is what they're saying. So that shouldn't apply to her. When she shared the motion with Mr. Kearney. Instead, she hoped he would publicize it so that the public at large would understand that she had been framed and would pressure the Commonwealth to drop her prosecution and instead prosecute the true perpetrators. The complaint itself alleges that Ms. Reed's purpose in sharing information with Mr. Kearney was to widely disseminate the information to cast suspicion on the plaintiffs and away from Reed. The statements made in the discovery motion shared with Mr. Kearney were made to influence, inform, or at the very least, reach governmental bodies, either directly or indirectly. There is thus a plausible nexus between the statement and the governmental proceedings, and therefore they were made in connection with an issue under consideration or review by a legislative, executive, or judicial body or any other governmental proceeding, and were reasonably likely to enlist public participation in an effort to effect Ms. Reed's first prosecution and then her retrial. They wanted to get the community to become active in this and make changes, so that's petitioning. The same is also true of Ms. Reed's statements to reporters that Ms. McCabe had perjured herself during her trial testimony in Ms. Reed's second trial. Ms. Reed made the statements on the courthouse steps immediately after the conclusion of that day's proceedings, but it's nothing that none of us didn't already know. Everybody knew she was lying. The purpose was to widely disseminate to the public her defense to the prosecution that the McCabes, the Alberts, and Higgins were responsible for Mr. O'Keefe's death. The goal was to galvanize public support and to pressure the Norfolk County District Attorney's Office to drop the prosecution or to refrain from a second retrial in the case of another mistrial. Thus, the allegedly tortious statement is similar to the statements made to the Boston Globe in Blanchard v. Stewart Carvey Hospital. In Blanchard, a hospital president made statements to the Boston Globe at the time the Commonwealth was considering revoking a hospital's hospital unit's operating license because of suspected abuse cases. The SJC held the president's statements were petitioning activity because the statement communicated to readers, likely including some of the licensing decision makers, that progress was occurring at the hospital and that its license to operate the unit should not be revoked. The statements were petitioning activity made in connection with the ongoing license proceeding because, one, they directly related to the Commonwealth's then pending investigation, and two, was in furtherance of the objective of the hospital's petitioning activity, the preservation of the hospital's license. Three, were issued in a manner that was likely to influence or at the very least reach the Commonwealth because it was made in the widely circulated globe. And four, the timing of the statements indicated a nexus with the investigation because they were made while the investigation was pending. Additionally, the SJC has ruled that speech and advocacy designed to foment public participation around a pending judicial proceeding constitutes protected petitioning under GLC 231. Okay. Similarly, here, Ms. Reed's statement to reporters that McCabe was untruthful directly related to the then pending prosecution supported Ms. Reed's petitioning activity in the proceeding to be acquitted, to have the claim dismissed, and to avoid a retrial in the case of a hung jury, was issued in a manner that would be widely reported as it was covered by local television news channels and was issued while the prosecution was still pending. The statement was thus petitioning activity. Finally, Ms. Reed's statements in the January 2026 Rotten Mango podcast were also petitioning activity because they were made, quote, in connection with an issue under consideration or review by a judicial body, end quote. In particular, even though the underlying prosecutions had ended, Ms. Reed was already defending a wrongful death claim brought by Mr. O'Keefe's family in Plymouth Superior Court, which had been filed in August of 2024. Ms. Reed's statements on the podcast were related to her case. They were intended to be widely publicized. Footnote 4. The Rotten Mango podcast has over 6 million subscribers at YouTube, making it one of the most widely distributed podcasts. Okay, where were we? I hate that. They were intended to keep her defense publicized and to persuade any judge or fact finder that she should not be held liable for Mr. O'Keefe's death. And they were intended to convince the O'Keefe family that it had sued the wrong party and should drop its suit. Thus, like her other statements with a plausible nexus to an ongoing proceeding, the overall context in which they were made shows that Ms. Reed's statements on Rotten Mango were made in connection with an issue under review by a judicial body and was reasonably likely to enlist public participation and therefore constitute petitioning activity. Number 2, the other non-defamation counts are all based on Ms. Reed's statements that constitute petitioning activity. In counts 3, 4, 6, 7, and 9, plaintiffs assert various non-defamation claims against Ms. Reed. They should also be dismissed under the anti-SLAPP statute because they are based on the same statements that underlie count 1, all of which fall under a broad definition of petitioning activity in the anti-SLAPP statute. The aiding and abetting counts, count 3, 7, and 11. Counts 3, 6, and 9 all allege aiding and abetting liability for 3 discrete torts allegedly committed by Mr. Kearney: defamation, intentional infliction of emotional distress, and negligent infliction of emotional distress. They all allege the same activity: aided and abetted Mr. Kearney's tortious conduct that Ms. Reed continuously and intentionally provided defendant Mr. Kearney with non-public or confidential information about her criminal case. The complaint's only allegations about Ms. Reed sharing non-public and or confidential information with Mr. Kearney are in paragraphs 28 and 49 through 51, all of which constitute petitioning activity. Paragraph 28 alleges that Ms. Reed forwarded her April 12, 2023 discovery motion, which had non-public documents attached to it. But as discussed above, the discovery motion is a court pleading and thus a written statement made before or submitted to a judicial body. In other words, it is petitioning activity. Paragraph 49 alleges that Ms. Reed falsely told Mr. Kearney through an intermediary that the Alberts provided grand jury testimony that Colin Albert was at the Alberts house the night of Mr. O'Keefe's death. Paragraph 50 alleges that Ms. Reed told Mr. Kearney, not public, the feds have been involved longer than anyone is likely guessing. Paragraph 51 alleges that Mr. Kearney published an audio file capturing McCabe's 911 call the morning Mr. O'Keefe's body was found and implies the file came from Ms. Reed or Ms. Reed's legal team. As with allegedly defamatory statements made directly by Ms. Reed, all of these statements that plaintiffs say constitute aiding and abetting defamation were petitioning activities because they were made in connection with an issue under review by a judicial body and reasonably likely to enlist public participation in an effort to effect such consideration. Like the alleged direct defamation underlying count 1, there is a plausible nexus between these statements and the prosecution. They were unable while Ms. Reed was being prosecuted and, as the complaint alleges, were made by the purpose of being widely disseminated to support Ms. Reed's defense. Statements forwarded to Mr. Kearney so that Mr. Kearney could selectively publish for the purpose of casting suspicion on plaintiffs and away from Reed, alleging Ms. Reed used Mr. Kearney as a tool to seed the public discourse with defamatory material. The emotional distress counts 4 and 7. Counts 4 and 7 allege intentional and negligent infliction of emotional distress based on Ms. Reed's alleged campaign of false and outrageous statements about plaintiff. The emotional distress claims appear to be based on the same statements and conduct underlying the direct defamation count and the aiding and abetting counts. Therefore, for the reasons outlined above, these counts are also premised on Ms. Reed's petitioning activity. Plaintiff's claim for negligent infliction of emotional distress dismissed because it grows out of the same nucleus of operative facts that spawn her defamation claim. Count 4 confirms that it alleges Ms. Reed orchestrated a coordinated campaign to falsely accuse the plaintiffs of murder and conspiracy to frame her, and funneled false statements to Mr. Kearney for maximum public dissemination. She didn't have that kind of time. I'm sorry. She was working on defending herself. She didn't have the kind of time that it would take to do everything that they're saying as far as aiding and abetting. I mean, it's just insane. In other words, the alleged purpose of Ms. Reed's statements and communications with Mr. Kearney was to widely disseminate her defense that plaintiffs were responsible for O'Keefe's death. Given this purpose and the widespread public dissemination, the statements and communications were petitioning activities. They were made in connection with an issue under review by a judicial body and reasonably likely to enlist public participation in an effort to effect such consideration. I need a drink, just 1 second. Okay. Plaintiff's final claim against Miss Reed, count 10, alleging civil conspiracy, is also solely based on petitioning activity. The complaint alleges that the conspiracy between Miss Reed and Mr. Kearney was an agreement to defame the plaintiffs and to inflict severe emotional distress on them. Again, the claim is based on the same allegedly defamatory statements and communications. They were made to widely publicize Miss Reed's defense while proceedings against her were pending in an effort for an acquittal and or to pressure the Commonwealth to dismiss the case and refrain from a retrial in the case of another hung jury. Like the other claims, therefore, count 13 is based on petitioning activity. Second stage, plaintiffs cannot show Miss Reed's petitioning activities were devoid of any reasonable factual support. Because all of plaintiffs' claims against Miss Reed are based on, now remember, this is the defamation case. This isn't the wrongful death case, okay? This motion to dismiss due to anti-SLAPP, under the anti-SLAPP law or statute, is the defamation case that the House defendants have against Karen and Aidan Kearney. Okay. Okay. So let's start that again. Because all of plaintiffs' claims against Miss Reed are based on petitioning activity to avoid dismissal under the anti-SLAPP statute, the burden shifts to the plaintiffs to show by a preponderance of the evidence that Miss Reed's petitioning activities were devoid of any reasonable factual support or any arguable basis in law and caused actual injury to them. As the SJC has stated, this is a difficult task, and even the submission of an affidavit showing a material dispute of fact does not suffice to show the petitioning activity was devoid of any reasonable factual support. In this case, plaintiffs Bristol Asphalt Supra. In this, which is footnote 6, let me see. The SJC's jurisprudence has texted. Okay, sorry. The SJC's jurisprudence has tended to equate the standard under the anti-SLAPP statute with the concept of frivolousness. Quoting Demulus Super something incorporated. Okay. A claim is frivolous if there is an absence of legal or factual basis for the claim, and if the claim is without even a colorable basis in law. Even where the petitioning does not end in the petitioner's favor, that does not in and of itself mean that it did not have some basis in law or foundation in fact. Okay. Oh, God. Where was I? Okay. In this case, plaintiffs cannot clear this high bar because there is ample evidence supporting Miss Reed's statements that plaintiffs caused Mr. O'Keefe's death and then tried to frame her. Of course, the simple and dispositive answer to whether Miss Reed's defense that she did not kill Mr. O'Keefe and that multiple parties attempted to frame her is devoid of any reasonable factual support or arguable basis in law was answered already on June 18, 2025, when a jury acquitted Miss Reed of all charges relating to the death of Mr. O'Keefe. Holding that judgment in favor of party to litigation is conclusive evidence that the petitioning activity was not devoid of any reasonable factual support or arguable basis in law. Noting that it is not enough for plaintiff to show that defendant's alleged petitioning activity was based on an error of law. He must show that no reasonable person could conclude that there was a basis in law for his position. There's no need for this court to reinvent the wheel here. Putting that analysis aside for the moment, however, the evidence supporting Miss Reed's position remains overwhelming. Below is a sampling. Miss Reed did not strike Mr. O'Keefe with her vehicle. The Massachusetts Chief Medical Examiner testified that Mr. O'Keefe's injuries were not consistent with a vehicle strike, but rather a physical altercation. Mr. O'Keefe did not show signs of a physical altercation before Miss Reed dropped him off, and he and Miss Reed did not have such an altercation before she dropped him off at the Alberts house. Mr. O'Keefe also suffered a contusive wound on the back of his head, which is consistent with falling on a ridged surface on the rigid surfaces present in the Alberts home garage. Mr. O'Keefe also suffered dog bite wounds on the Alberts, and the Alberts German Shepherd had a history of aggression. Mr. O'Keefe's phone was at some point inside the Alberts home. Ms. McCabe had used her phone to search at 2:27 a.m. on January 28th how long it takes for a person to die in the cold. It should say January 29th, right? Because 2:27 a.m. is the next day. In the early morning hours of January 29th, Mr. O'Keefe's body was not present in the spot it was later found, as Brian Loughran said. Testimony of Brian Lucky Loughran, oh, that's telling you about where his affidavit is. Instead, a Ford Edge was parked in the spot, though it was not present when Miss Reed dropped off Mr. O'Keefe. Brian Albert owned a Ford Edge at the time. So there's that. Dr. Elizabeth Laposada, the former chief medical examiner for Rhode Island and a professor at Brown University, opined that Mr. O'Keefe died from a massive skull fracture and was inconsistent with a vehicle strike. Dr. Laposada further testified that due to the abrasions on the back of Mr. O'Keefe's head, the injury was most likely caused by falling backward onto a ridged surface, and she observed no evidence of any ridged surface where his body was found. She also testified that she found no evidence that Mr. O'Keefe suffered from hypothermia. She testified further that the wounds on his right arm were consistent with an animal bite or claw marks. In addition, there is ample evidence that plaintiffs have made material misinterpretations in previous sworn testimony, rendering suspect any sworn statements offered in this case. Those misrepresentations include Brian Higgins. Mr. Higgins originally told police he went to the Canton Police Department on the morning of January 29th to do administrative work in the middle of a snowstorm and drunk. Mr. Higgins then told the grand jury and said he went to the Canton Police Department to move cars around. Yes, later at trial, video evidence showed Higgins moving a large parcel from yet later at trial, video evidence showed Higgins moving a large parcel from one vehicle to another, disappearing into his office, and then spending a period of time in another unseen area of CPD, and then finally exiting CPD. Mr. Higgins testified that he didn't speak to anyone after leaving the Alberts house until he was notified of Mr. O'Keefe's death the morning of January 29th. However, evidence at trial showed that he and Brian Albert communicated by phone at 2:22 a.m. that morning before Mr. O'Keefe's body was found. Nicole and Brian Albert, on January 29th, they told Sergeant Link that their daughter, Caitlin Albert, was only briefly at the Alberts house and left around 12:15 a.m. However, Caitlin was later interviewed by MSP and said she was the last to leave 34 Fairview. Trial testimony by all of the house defendants confirmed Caitlin was the last to leave the Alberts house at around 2 a.m. Nicole Albert told police she was asleep until Miss McCabe came into her bedroom just before 7 a.m. on January 29th. However, call logs show a 38-second answered call from Jen to Nicole at 5:07 a.m. Brian Albert testified that he didn't make any calls during the night of January 29th, but call logs show activity between him and Brian Higgins at 2:22 a.m. Jennifer McCabe. Ms. McCabe falsely identified herself as Nicole to interviewing FBI agents and falsely told them that she had not made any phone calls in the brief period after the agents first showed up and then returned for questioning. After being threatened with the penalties of lying to agents from another organization, Ms. McCabe admitted to calling her husband, Brian Albert, Peg O'Keefe, and Adam Lawley. Ms. McCabe omitted during her trial testimony that she went to Sergeant Lank's house on January 30th until the defense presented her phone's location data. She also testified that she drove straight to Sergeant Lank's house from the O'Keefe's house, but her path of travel showed that she went directly to Sergeant Lank from her own house after stopping at the Alberts house. She also denied ever stopping at the Alberts house, but the phone data at trial revealed a 5-minute stop on the way to Sergeant Lank's residence. Now, if you have nothing to hide, why are you lying so much, right? All of them are lying. Ms. McCabe falsely told first responders that Ms. Reed said, "Could I have hit him?" She later testified at trial. Ms. Reed said, "I hit him, I hit him, I hit him." Besides the physical evidence and the evidence that plaintiffs have made numerous material misstatements in previous testimony, plaintiffs have also destroyed multiple pieces of evidence with the knowledge that the evidence would be relevant to any prosecution and later civil litigation. Mr. Higgins and Brian Albert destroyed their phones after a court order to preserve them. Even though she didn't destroy her phone, Ms. McCabe deleted many of her texts as well as the 2:27 a.m. Google search. At the very least, the court should draw an adverse inference that the deleted information would not have supported plaintiff's statements that they had nothing to do with O'Keefe's death. Where evidence has been destroyed or altered by persons who are parties to the litigation and another party's ability to prosecute or defend the claim has been prejudiced as a result, we have held that a judge may exclude evidence to remedy that unfairness. Given all this evidence, plaintiffs cannot carry their burden at the second stage of the anti-SLAPP analysis to establish that Ms. Reed's statements were devoid of any reasonable factual support. Dismissal of plaintiff's claims against Ms. Reed is therefore appropriate under the anti-SLAPP statute. Roman numeral 2, plaintiff's claims do not state a claim or relief and should be dismissed under mass, and gives the statute. Even if the court denies the special motion to dismiss, plaintiff's claims should still be dismissed for numerous reasons. A, count 1, defamation. Count 1 of the complaint alleges defamation, which requires proof that the defendant was at fault, or 2, the publication of a statement regarding the plaintiff capable of damaging the plaintiff's reputation in the community, which it was already damaged, let me tell you, which either caused economic loss or is actionable without proof of economic loss. 1, the complaint does not comply with mass, and gives the statute, because it does not specify the allegedly defamatory statements. Count 1 should be dismissed because plaintiffs do not identify which statements made by Ms. Reed allegedly constitute defamation. Instead, they state that the complaint does not include each and every example of Reed's and Kearney's defamatory statements and conduct. Complaint at 5N1. Okay. Count 1 itself does not identify any statements apart from the generic allegation that Ms. Reed made false statements asserting or reasonably understood to be asserting that the plaintiffs were responsible for the murder of John O'Keefe and a cover-up of their purported role in that murder. This vague pleading runs afoul of the statute. Short and plain statement requirement because it does not provide Ms. Reed with notice of the basis of plaintiff's claim against her. The complaint's vagueness makes it impossible to formulate a response to the allegations. For instance, the complaint alleges that Ms. Reed's alleged defamation campaign began on April 18th, 2023. Yet the complaint also alleges that Miss Reed knowingly and falsely told police before her second arraignment that Brian and Colin Albert beat up Mr. O'Keefe and that she was not responsible for her death. The complaint also refers to statements made in a discovery motion filed by Miss Reed's attorney, which was forwarded to Mr. Kearney on April 12, 2023. If these statements are the allegedly defamatory statements underlying count 1, they are subject to dismissal because they were made more than 3 years prior to the complaint's filing on April 16, 2023. Oh my. The statements made in the discovery motion are also absolutely privileged under the litigation privilege. Statements made in the course of judicial proceeding which pertain to that proceeding are, of course, absolutely privileged and cannot support a claim of defamation, even if uttered with malice or in bad faith. There you go. The other statements by Ms. Reed identified in the complaint similarly do not constitute actionable defamation as explained Infra Part 2A2. God, how much longer? However, apart from the statement listed in the complaint, Ms. Reed cannot fully respond to count 1 to the extent it relies on other statements that are not included in the complaint. For that reason, count 1 should be dismissed because it does not provide a short, plain statement of the defamation claim. Oh my God, I don't know how people do this. I don't know how lawyers, this is like mind-numbing because they have to repeat everything for every count. It's like, let's get to it. You guys are burning trees, going through trees like crazy with all this shit. Why can't we just get to it? Why can't you just say, see reasons above, see reasons above for each count? Why do you have to go through each reason that the count should be dismissed? It's just insane. And they're worried about, global warming and all that. I mean, how many trees do courthouses go through with all their filings? It's insane. There's got to be a better way. However, apart from the statement listed in the complaint, Ms. Reed cannot fully respond to count 1 to the event it rules on other statements that are not included in the complaint. For that reason, count 1 should be dismissed because it does not provide a short, plain statement of the defamation claim. Number 2, nearly all of Ms. Reed's actual statements listed in the complaint are not actionable defamation as a matter of law. As explained above, count 1 cannot be premised on the June 2022 statement by Ms. Reed and the April 12, 2023 statements made in the discovery motion filed in Norfolk Superior Court. Because the claims would be untimely and barred by the absolute litigation privilege, because the claims would be untimely and barred by the absolute litigation privilege period. Other statements by Ms. Reed listed in the complaint are also not actionable defamation. A, paragraph 49, statement about Albert testimony to grand jury. Paragraph 49 alleges that Ms. Reed told Mr. Kearney through an intermediary that Brian Albert and the other non-plaintiff members of the Albert family testified to an investigating grand jury that Colin Albert was at the Albert's house prior to O'Keefe's arrival. This statement, even if false, is not defamation. A defamatory statement is one that discredits the plaintiff in the minds of any considerable and respectable segment in the community. A statement that Brian Albert correctly told a grand jury that Colin Albert was at the Albert's house does not discredit Brian Albert or injure his reputation. Now, I'm pretty sure he's done that himself. B, paragraph 50, statement about Fed's involvement. Paragraph 50 alleges that Ms. Reed told Mr. Kearney through an intermediary that the, quote, Feds have been involved longer than anyone is likely guessing, end quote. This statement is not actionable because, even if false, it is not of and concerning the plaintiff. Yeah, they don't say anything about the plaintiff in that statement. They're assuming that they're talking about the plaintiff. That's consciousness of guilt, if anything. In other words, the statement does not refer to the plaintiffs, and no person could reasonably understand the statement referred to the plaintiffs. In addition, the statement is not one of fact, but rather an opinion about the length of federal involvement. True that. See paragraph 51, January 29, 2022 voicemail excerpt. Paragraph 51 implies that Ms. Reed or her legal team provided an excerpt of a voicemail Ms. Reed left Mr. O'Keefe the morning of January 29th, which captured Ms. McCabe's call to 911. There is no allegation, however, that Ms. Reed made any statement of or concerning Ms. McCabe or the other plaintiffs, and no allegations that any statement in the voicemail were false or injurious to plaintiff's reputation. This is all consciousness of guilt. The fact that they think that these are all defamatory things, to me, shows consciousness of guilt. Paragraph 58, Yannetti text regarding HPO. The next statement the complaint attributes to Ms. Reed or her lawyers is in paragraph 58, which alleges that Ms. Reed's attorney, Mr. Yannetti, or King, texted Mr. Kearney that the Stoughton District Court had denied any ex parte harassment prevention order Ms. McCabe had sought against Mr. Kearney. This is true statement, cannot be defamation. Holding the plaintiff must show statements in question were capable of being proved false, and also does not tend to discredit Ms. McCabe or injure her reputation. E, paragraph 75, Facebook group hosting and posts. Paragraph 75 alleges that Ms. Reed was a co-administrator of a Facebook group that became a feeding ground for defamatory and harassing posts made regarding the plaintiffs. But the paragraph does not allege what statements were made, when, and by whom, nor does it allege that Ms. Reed was responsible for any of these third-party posts. If Ms. Reed did not make or publish the unidentified statements, she did not defame the plaintiffs. Noting that to prevail on a defamation claim, a plaintiff must establish that the defendants published a false statement. To the extent plaintiffs are alleging Ms. Reed's administration of the Facebook group constitutes defamation, she is immune under Section 230 of the Communications Decency Act. Quote, courts analyzing and applying the CDA have consistently held that distributing, sharing, or forwarding content created and or developed by a third party is conduct immunized by the CDA, end quote. As for Ms. Reed's own statements on the Facebook page, the complaint does not allege any were false, just that she shared confidential information regarding her criminal case that had not been previously known to the public. Just because it wasn't previously known to the public doesn't mean it was confidential, right? They're intermixing the two, and they're two totally different things. Not made public and confidential are two totally different things. The complaint also does not allege that any of Ms. Reed's Facebook posts concerned plaintiffs or injured their reputations. Without alleging these basic elements, any defamation claims premised on Ms. Reed's unidentified Facebook posts fail as a matter of law. F, paragraph 115, statement by Jackson to Nightline. Paragraph 115 alleges that Ms. Reed's attorney, Mr. Jackson, said on an episode of ABC's Impact X Nightline show that, quote, there are people in that house that are actually responsible for his death and who murdered him. And there are others in the house that are covering up that murder, end quote. That's true. That's a true statement. It also alleges that Mr. Jackson said that Ms. McCabe knew Mr. O'Keefe was murdered in the house and that his body was placed outside. Any defamation claim premised on these statements should be dismissed. The complaint does not allege Ms. Reed is vicariously liable for her attorney's statements. Even if it did, a principal's vicarious liability turns on whether the agent is liable. Thus, the complaint must plead that Mr. Jackson is liable for defamation, which requires an allegation he was at fault. The complaint does not allege any fault on Mr. Jackson's part, whether negligence, recklessness, or knowledge of falsity. Thus, the complaint does not sufficiently allege Jackson's liability for defamation and therefore fails to allege Miss Reed is vicariously liable of Mr. Jackson's statements. G. Paragraph 130, statement on January 12th, podcast. Paragraph 130 of the complaint alleges that Miss Reed told the Rotten Mango podcast that Mr. O'Keefe entered the Alberts' house and that someone in that house killed John O'Keefe. These statements do not support a defamation claim because they are not of and concerning any individual plaintiff. Instead, the statements are made generally about the group of people in the house, only some of whom were the plaintiffs. Defamation does not lie when a statement is made about a group unless the size of the group or the context of the statement would make it reasonably understood the statement referred to the individual plaintiff. There can be actionable defamation when a defamatory statement applies to all members of a small group or when the statement refers to multiple members of a small group. That is, the defamation encompassing a considerable proportion of the group can be seen as a blanket slur, reaching all. Here, however, the statement is only about a single unnamed individual in a group, which does not support an inference the statement referred to an individual member of the group. But we have discovered no case where a group libel justifying suit by all members was held to arise from a slur against one unidentified member. The aiding and abetting and civil conspiracy counts 3, 6, 9, and 10 should be dismissed because the complaint does not allege how Ms. Reed substantially assisted Mr. Kearney other than making privileged statements. Counts 3, 6, and 9 allege that Ms. Reed aided and abetted Mr. Kearney's defamation, intentional infliction of emotional distress, and negligent infliction of emotional distress. To make out a claim against Ms. Reed for aiding and abetting Mr. Kearney's tortious conduct, plaintiffs must plead and prove that 1, Mr. Kearney committed the relevant tort, 2, that Ms. Reed knew he was committing the tort, and 3, that Ms. Reed actively participated in or substantially assisted in his commission of the tort. The civil conspiracy claim, count 10, has similar elements. There are 2 types of civil conspiracy. The first is a very limited cause of action that arises when the defendants acting in unison had some peculiar power of coercion over plaintiff that they would not have had if they had been acting independently. But we know that's not true. Plaintiffs do not allege this type of coercive conspiracy. Instead, they allege a concerted action conspiracy in which liability is imposed on one individual for the tort of another. This type of conspiracy, like an aiding and abetting claim, requires plaintiffs to plead Ms. Reed knew that Mr. Kearney's conduct constitutes a breach of duty and gave substantial assistance or encouragement. Both types of claims, the aiding and abetting claims and the civil conspiracy claim, must be dismissed for 2 reasons. First, Ms. Reed cannot be held liable for aiding and abetting or conspiring to assist Mr. Kearney's tortious activity if he did not commit a tort. As explained in Mr. Kearney's motion to dismiss, the tort counts against him do not state a claim. Defendant Aidan Kearney's memorandum of law in support of his partial motion to dismiss pursuant to Massachusetts R. Civil Penal Code 12B6. Second, the complaint does not allege substantial assistance that would support aiding and abetting or conspiracy claims. The complaint alleges that Ms. Reed substantially assisted and encouraged Mr. Kearney by when she continuously and intentionally provided defendant Mr. Kearney with non-public and or confidential information about her criminal case. And by funneling information and false statements to Mr. Kearney. Neither of these actions constitute substantial assistance for Mr. Kearney's alleged torts. I need to take a drink, just 1 second. Okay. Sorry about that. With respect to sharing non-public information, and as discussed above, the only alleged non-public confidential non-public/confidential information shared was one, Reed's April 12th discovery motion, which had non-public documents attached to it. 2, statements about the Alberts grand jury testimony. 3, a statement that feds have been involved longer than anyone is likely guessing. 4, an audio file of Miss McCabe's 911 call. And 5, the denial of Miss McCabe's ex parte harassment and prevention order. All 3 aiding and abetting counts are based on the theory that sharing these pieces of non-public/confidential information helped Mr. Kearney spread the alleged false statements that plaintiffs killed Mr. O'Keefe and then sought to cover it up. The complaint does not allege, however, how sharing such information provided any assistance to Mr. Kearney to lie about plaintiffs. Other than the April 12, 2023 discovery motion, none of these alleged sources of confidential information stated or implied that plaintiffs were responsible for O'Keefe's death and thus did not support or encourage Mr. Kearney's allegedly defamatory statements that plaintiffs killed Mr. O'Keefe and covered it up. While the discovery motion did name Brian and Colin Albert as responsible for Mr. O'Keefe's death and Miss McCabe for covering it up, Miss Reed is absolutely immune under the litigation privilege for statements made in the motion. Dismissing aiding and abetting claims premised on statements and conduct protected under litigation privileges. For the same reason, the allegations that Miss Reed funneled false statements to Mr. Kearney, complaint paragraph 213, does not support the civil conspiracy claim. The complaint's only allegation that Miss Reed funneled false statements to Mr. Kearney was sharing the publicly filed discovery motion. But Miss Reed is immune from claims premised on her privileged statements made in the motion. C. Counts 5 and 9. Counts 5 and 9 assert claims of intentional and negligent infliction of emotional distress, respectively. Both claims are based on Miss Reed's alleged campaign of outrageous and false statements. The claims are thus based on Miss Reed's allegedly false statements. However, defamatory statements cannot, as a matter of law, satisfy the extreme and outrageous conduct requirement of the IIED claim. Moreover, even if plaintiffs could maintain emotional distress claims based on defamatory statements, because the defamation claims based on those statements fail in this case, the emotional distress claims should also fail. Holding the claim based on false statements cannot be brought in the guise of an IIED claim, which would divorce it from the well-developed law of defamation with its attendant privileges and defenses. In particular, the statements Miss Reed made to the police in June 2022 and in the April 12th discovery motion are protected by the litigation privilege because the statements which form the basis of Corellas versus Veneris. Because the statements which formed the basis of Corella's claim for intentional infliction of emotional distress were made in circumstances rendering them absolutely privileged, that claim must also fail. A privilege which protected an individual from liability for defamation would be of little value if the individual were subject to a liability under a different theory of tort. Similarly, the statements referred to in paragraphs 49, 50, 51, and 58 about the Alberts testimony to a grand jury, the Fed's involvement, a voicemail excerpt containing Miss McCabe's 911 call, and the denial of Miss McCabe's ex parte harassment and prevention order do not injure the Alberts' reputation and thus cannot constitute extreme and outrageous conduct for purposes of an IIED claim. Similarly, because these statements are not injurious to plaintiff's reputation, no reasonable person would have suffered emotional distress as required for an NIED claim. Likewise, the statements of Facebook posters and Attorney Jackson in paragraph 75 and 115 cannot constitute IIED, which requires that the actor intended to inflict emotional distress or that he knew or should have known that emotional distress was the likely result of his conduct. They also cannot underlie an NIED claim, which requires that the claimed harm result from Ms. Reed's alleged negligent conduct, not the alleged defamatory statements of third parties. The actor's negligent conduct is not a substantial factor in bringing about harm to another if the harm would have been sustained even if the actor had not been negligent. Finally, the statement made to the Rotten Mango podcast that someone in the house killed John O'Keefe does not support emotional distress claims because, as argued above, the statement does not identify a particular individual and thus are not defamatory as to any of them. Conclusion. For the foregoing reasons, defendant Karen Reed respectfully requests that the court allow her motion to dismiss and she be awarded her reasonable attorney's fees and costs. See, they just recopied it over and over and over and over and over. So, yeah. There's not 900 and something pages. I don't know why they keep doing that. I don't know if they do that to discourage us from covering them and going through them or going over them because they think that we'll look at that and be like, holy shit, 900 pages. No way. Ain't going to happen. Even if it was 900 pages, I think we would all find a way to cover it. So there are more things on the docket for the defamation case that need to be gone over, but I'm exhausted. This stream is extremely long already, and I should have split the two cases so that there's no confusion as to what was in reference to the wrongful death case against Karen Reed and what is in reference to the defamation case against Karen Reed and Aidan Kearney, because I have things from both of those dockets included in this video. So I apologize for that. The next video will be strictly on the defamation case, and I will most likely post it tomorrow. But yeah, let me know how you guys feel about this. I mean, what do you think? Do you think that the motions to dismiss the defamation cases will be granted? I don't know. Judge Gildea is really losing my is slowly losing my support because like I said, I liked him a lot at the beginning, but he's slowly changing that opinion and by his actions. And I don't know what he's doing. I don't know if he, because they are appointed, they are not elected. So I don't know if somebody got to him and he's worried about not being or having his appointment taken away or what, but he has definitely done a 180 as far as his attitude goes towards Karen Reed and Aidan Kearney. And I think he should definitely recuse himself in the Aidan Kearney case because he has already shown his bias against Aidan Kearney by believing that he was the leak of Proctor's medical information and, without even checking into it. And he said that, he's made it clear that social media posts are not evidence, and yet he's choosing to believe that social media post was posted by Aidan Kearney, but it wasn't leaked because he posted it before the stay and the order to impound that information was made. Aidan Kearney had a third-party anonymous tip, and he read it, and he made the disclaimer that he didn't know if it was true, but he was reading it anyway. But they basically told us that that's what is going on with Proctor because they said that it was leaked. So that must have been right if they thought it was leaked. I don't know. So let me know in the comments what you think will happen with this, and whether or not you think the judge should recuse himself in regards to the Aidan Kearney defamation case, because you know you don't want, it doesn't matter if he's biased or not. It's the appearance of being biased, right? I mean, that's ultimately what it comes down to, is the appearance. It matters how it appears, not whether or not it's true. Just matters if the appearance, if it appears that you are. So I don't know. I think that, I don't know. Anyway, so yeah, let me know in the comment section what you think about that. And again, I appreciate you joining me, and don't forget to like and subscribe. It's free. And yeah, I hope everybody has a good rest of your day. Yes, Karen Reed had a hearing today, so I will find out what transpired in that hearing, and I will cover that at the very beginning of my next video, because that, if it's in regards to the defamation case. If it's only in regards to the wrongful death case, I'll wait and do a video on that alone, because I don't want to conflict the two cases. It's already a shit show, and it's almost impossible to keep the cases separate, and it's so confusing and so overwhelming. I mean, yeah. So, I mean, Melanie Little has been doing this full time, and she's having a hard time keeping up. So it's crazy. So anyway, don't forget that tomorrow's the first day of the rest of your life. And ciao for now. Don't forget to like and subscribe. Thank you. Bye.